Good afternoon. Welcome to Lawyers and Friends, episode 37, The 7 Deadly Sins and Workers' Compensation. My name is St. Thomas Aquinas. You may remember me from your philosophy class. No? Well, then perhaps you remember me from the Divine Comedy. Remember, I was in the Paradisimo, not the Inferno. Still no? Well, then perhaps you remember my work on the 7 Deadly Sins from the 1995 hit Seven, starring Morgan Freeman and Brad Pitt. That one you remember. Now, you're probably wondering, Mr. Aquinas, please, call me St. Tom. Mr. Aquinas is my father. You're probably wondering, St. Tom, you've been dead for like 800 years. What can you possibly teach us about workers' compensation? Well, first of all, lose the attitude, okay? But you'll find that the 7 deadly sins have a lot of applications for both lawyers and clients and adjusters, and why avoiding them is really important to avoid ruining your case. And I can tell you are still not convinced. Well, luckily I brought, I wouldn't say a friend, but a longtime adversary. And if you're not going to listen to me, then perhaps you'll listen to my friend. Well, not really friend, but acquaintance here. Please welcome Princess of Darkness, the Lord of the Underworld, second place finisher of a Georgia fiddling contest, the Devil, Lucy Furr.
Thank you so much, Tommy. But did you really have to bring up that Georgia fiddle thing? You know that's a sore point, and you call yourself a saint? I don't know. We may have to rethink that.
Well, just a little friendly banter, if you will. Well, if there was an 8th deadly sin, it would be wasting time. So why don't we get started? So before anyone shouts out, "What's in the box?" you can see the box listed right here, and it's the 7 deadly sins: gluttony, greed, lust, wrath, sometimes called anger, pride, envy, and sloth. So we'll start with the first one, gluttony. Now, gluttony, although it's often considered with food, it's not always. Gluttony can be anything with an overabundance, overindulgence. In this case, as it applies to lawyers, it can be considered for taking on too many cases and an overindulgence in that sense. You often see this with other defense firms, and where you get an assembly line defense, taking on too many cases rather than an individualized attention. Now, I know the good saintly attorneys at LOMAD don't do this, because that's against the LOMAD mission that breaks the mold of assembly line defense and embraces claim-based partnerships centered around collaboration, communication, and honesty.
But let's talk about the adjusters and the adjusters and the clients. Where's their gluttony? Too many doctors, head, shoulders, knees, and toes. The neck bone's connected to the little finger. How did they do it? Well, why did they do it? They just want to keep treatment going. Keep going, keep going. Let me get that total disability. Oh, wait, this guy said I'm only partially disabled, but Dr. B says I'm totally disabled. I can continue to get benefits. And what does that mean? That means that for every doctor the claimant has, the carrier has to get an IME. Because if you don't counter what their doctor says, well, guess what? The law judge is going to say, I'm going to look at that one doctor who says a total disability instead of the 6 other doctors who say the guy can go back to work. That prolongs litigation. You have a lot of depots. Yes, you depose every doctor because you have no choice in doing it. But it's not just the claimants who might be asking for too many doctors. It can be the carriers. You don't like what one IME said because he said total? I'll go to another IME. Let's see what he says. He says partial. And now we're off to the races again, taking more testimony. So doctor shopping on both sides, it can mess up your claim. It'll prolong the case, and doctors can contradict themselves. Be careful about doing it.
Very good. We go to greed. Cut off there, but it's greed. Now, funny thing about greed, in the movie Seven, the victim of greed is a lawyer with the last name Gould. I'm sure glad I'm St. Thomas Aquinas and not someone who fits that description. But in an example of greed for lawyers would be overvaluing or undervaluing a case, or overvaluing or undervaluing the probability of an outcome in order to steer the client in a direction you want to go, particularly when there's a less risk-adverse option that the client may want to consider. And it's important that under New York Rules of Professional Responsibility 1.2, the lawyer shall abide by the client's decision whether to settle the matter. Communication is important, and it's the client's decision that needs to be recognized and respected. And similarly, in Rule 1.1 with communication, the lawyer shall is legalese for must, promptly inform the client of all decisions, circumstances requiring the client's informed consent. Any material developments, including a settlement or plea offers. The lawyer shall reasonably consult with the client about means to accomplish the client's objective, inform the client about the status of the matter, comply with the client's reasonable request for information, and consult with the client about the limitations of the lawyer's conduct. And most importantly, the lawyer shall explain a matter to the extent reasonably necessary to permit the client to make an informed decision.
Let's take a look at a real life case of somebody some of you may know, a guy named Richard Harris. Mr. Harris did a lot of bad things at the compensation board, and he wasn't too smart about it because he got caught. I mean, if you're going to commit the crime, don't do it unless you can do the time. Well, he pled guilty to charges involving filing of false documents, a Class 2 misdemeanor. And as part of that criminal case, he agreed to not appear before the board for 3 years and to change his firm and to not submit any fee applications. But that wasn't good enough for the appellate division. The appellate division said, nope, we're going to file a grievance complaint. And they went before a special master, a special referee, who came up with a lot of charges. And we're going to see a few of them a little later. One of them was for submitting legal fees to the board that contained false statements. And that is in violation of rules of ethics, the Code of Professional Responsibility. Eventually, the appellate division said, what you did was so bad, we're going to turn around and suspend you from the practice of law for 3 years. So not only can you not appear before the board, you can't appear before anybody. And as part of the criminal case, he had to pay back the almost $85,000 that he got for his ill-gotten gain. Just proof crime doesn't pay.
Greed also occurs with adjusters and clients. For example, rejecting a settlement that's fair or a stipulation when it's presented and advised because you believe that you can get better at trial. Now, it's important to remember how you view the case is not necessarily how the judge or the board views the case. There's almost always the element of danger in going to trial or continuing litigation, even when the counsel gives the best possible information to make an informed decision. A victory in one case does not guarantee a victory in every case with a similar set of facts. Another example would be a WCL 14A. The employer who employs a minor in violation of labor law. Now, this would be an example of the employer's trying to pay a minor under the table, save on taxes or what have you. The employer, not the carrier, is liable for double award if the if the injured employee, the minor employee, has an injury. And of course, this may also create a conflict of interest between the employer and carrier. Again, greed in the long run may create additional unforeseen problems. We go to lust. Now, you're probably wondering, how on earth can lust pertain to workers' compensation? I mean, there's the one guy at LOMAD who's sort of a cute, sort of quirky, who goes way overboard in his costumes, but he's like a Buffalo 6 at best. I hear you. But lust in this case, think of it more as an obsession, an unhealthy obsession. For an example, an obsession with a strategy of a desired outcome, regardless of the facts. It's important to be flexible with facts as they're presented themselves. If you're going through medical records or deposition testimony, and if new things come up that radically changes the way you see the case, you can't be tied down with the original strategy as much as you may have loved the original strategy that you've set forth. And of course, this goes back to the LOMAD vision. We have an intimate workers' compensation defense that provides a voice to employers, and it goes to the LOMAD values. We have intellectual curiosity by fostering an environment of lifetime of learning through issue spotting with a focus on candor and character. So again, you won't have any lust for a specific strategy from any attorneys at this firm, the good saintly attorneys that they are.
There are rules that lawyers have to follow for just about everything. And one of those is to act as an advisor. You turn around and you use your judgment and you give fair and honest advice. Mind you, we don't follow that in hell. We've got our own set of rules down here. We've got our own big ring of lawyers. Where I'm sitting in the general counsel's office. It's pretty far down, and there are a lot of them here. So if you don't want to end up where I am, and let me tell you, it is hot as hell down here, follow this rule. Give fair advice. Tell your clients what the real deal is. And if you do that, you won't be seeing me.
A good example for lust, as it may ruin a case from the adjuster or client standpoint, is a lust in an IME doctor. Just because a doctor says things you want to hear, it may not make sense or really be helpful for the case. An example is there's a certain downstate doctor who maintains that there's no consequential injuries in orthopedics from an overuse or overcompensation. Now, this may be a good opinion if the issue is whether there's consequential body part, but if that part has already been established and we're looking for an opinion on permanency, then having the doctor write a report for a 0% SLU when the site's already been established, the judge isn't going to give much credibility to it. So having this obsession with this doctor, ultimately it's not going to help the case in the long run. This one is me. Wrath, anger. Lawyers, do not turn minor annoyances into unnecessary feuds. We see the same adversaries and judges over and over. A recent example I've experienced is that we had a deposition scheduled and confirmed, and the claimant requested the time to be moved because they had a hearing scheduled, and apparently suddenly there was a new conflict that was created. The staff thought that we'd want to put a statement on the record and seek preclusion. No, we were able. It was simpler and better for everyone if we could move the hearing up, move the deposition up 10 minutes, and if we absolutely had to, we could take a pause for 5 to 10 minutes while they went on the record for their hearing. It's a reasonable one-time accommodation that allows us to get the deposition done before the deadline, and it helps maintain a good professional courtesy with the adversary. And should a situation arise when we need a similar accommodation, it will create a good relationship. If we got into a feud over this, obviously they're going to remember that, and they wouldn't give us the same courtesy. Don't let minor things become major ones.
Oh, it's those pesky rules again. You lawyers, you just have rules for everything. We don't follow any of this down in hell, by the way. But if you're a lawyer, do this. Make sure you know what the local customs are. What does that judge do? What do you have to do? If you're not going to do something, tell the guy on the other side you're not going to do what the custom is and why you're going to do it. Make sure you're courteous. You know, you spent a lot of money to get that degree. Act accordingly, or else you might just end up down here. Don't violate the rules of evidence. Just don't do it. That gets you in trouble, and that gets you down here. And don't act like a jerk when you're in court. Just don't do it. It demeans you. It demeans your office. It demeans your degree. And this is a true story. I heard a story that a Lomat attorney was doing a deposition, and the court reporter said, "You're not going to believe what happened in this deposition." All of a sudden, the claimant's attorney started cursing out the IME doctor, and it went downhill from there. Nobody wants to see your curse words in a record. It's just not nice. So either you play nice or don't play at all. Don't run with scissors. Be good boys and girls, or else you might just see me, or worse than me, the appellate division.
A good example to what Lucifer just mentioned. There's a case, New Caps LLC, just what she just spoke of. Claimant's attorney and carrier's attorney got into an argument. They were arguing, and the review of the proceedings in this case showed that conduct of the attorney and the attorney for Great Divide, the carrier and claimant's attorney engaged in disruptive conduct, raised patently frivolous contentions and issues, and made factual misrepresentations of prior proceedings held in the case. But only the carrier's attorney was assessed the penalty of $500. And here's what I think the distinction is. The carrier's attorney made ad hominem attacks against the WCLJ and his impartiality. Don't do that. Okay. We all know that sometimes the judge can be biased. Making ad hominem attacks to that effect against the judge, that's not going to get you anywhere except fined. That's not something to go back to the client or to your superior, and it looks really bad on the record. It's all it does is hurt the case. Adjusters, clients, don't become any less professional just because you have a difficult claimant. I used to work on the claimant side. Really, St. Thomas Aquinas used to practice claimant's law? Yes, that part's not in my Wikipedia page. I know it's easier said than done, but New York actually has a lot of provision for penalties. And don't let, and we used to see all the time that, and it was always the most difficult clients that all of a sudden that their temp check, suddenly that every so often that it was always the difficult client that the temp check would come late, and it always seemed like they were playing games. Please don't take just because a person is difficult or sleazy and we know who they are. Don't lower yourself to that. It's only going to make the case much more difficult. And as stated, New York has a lot of penalties. They're not worth it.
This is something that your employers might see. It's Section 120 of the Comp Law, retaliation. If an employee files a compensation claim or an employee testifies in a compensation case, an employer cannot fire that employee just because they filed a claim or testified. They have the right to do that. And if they get fired because they filed a claim or testified, it's the employer who's in trouble, not the claimant. And the employer has to reinstate the claimant or the employee and compensate them if they're found guilty of retaliation. But Do you have to get involved as an adjuster? No, not if you're an insurance company, because your insurance policy doesn't provide coverage for a Section 120 retaliation. But if you're a self-insured employer, you're going to have to defend that claim. Even if you're an employer with insurance, you still have to defend that claim. You've got to pay for somebody to represent your interest. A retaliation claim is heard before the comp board, but there are no presumptions. The claimant has to prove by substantial evidence that he got fired because he either filed a claim or testified in the case. It's a plain old trial, just like you would see in what people would say is real court, not comp court, but it takes place in comp court. So if you're a self-insured employer, make sure that if you fire an employee, it's not because they filed a claim. It's got to be for some other reason. Back to you, Tommy boy.
Thank you, Lucy. Pride. Now, just a word about pride, because this is the sin that's considered the deadliest of the deadly sins, but it's also the most confusing. Most people would say, well, I'm proud of my son who worked really hard and got into the U.S. Naval Academy. How is that a sin? It's not. Okay. Pride usually, in this sense, should be more thought of as arrogance. And it's considered the deadliest of sins because it actually overlaps with all the other sins. For example, someone who cheats on their taxes or cheats on their spouse or whatever. That person, obviously committed other sins, but there's also the pride of thinking that the rules don't apply to you. That's why it's considered the deadliest of sins. But looking at a pride-specific example as it pertains to workers' comp, for lawyers, not adequately preparing for a hearing simply because the hearing appears simple. The sense is that, well, it's a simple, non-established body part, simple issue. Well, confidence is good. We've had a number of cases where what seems like a simple case, there's more to it that both the attorney and the justice need to be aware of and need to be on the same page. In other words, know your file. There's usually more going on than what's on the hearing notice. And of course, this goes to, once again to the low MAD values. Goal-oriented collaboration. We pride ourselves, see, this is the good kind of pride. We pride ourselves on our collaborative working relationships with both clients and colleagues. Low MAD's holistic approach allows for an in-depth understanding of true partnerships with employers. And a perfect way to avoid the sin of pride in this context is asking questions to a colleague or doing the necessary research on an unfamiliar or novel issue. And this, of course, goes to once again, Lucifer's favorite things, rules of professional conduct. This goes to New York Rules of Professional Conduct 1.1, rule of competency. The lawyer must be competent when representing the client. Ask the more experienced attorney when necessary, or if it's really novel, do the research. And then you won't ever be guilty of the sin of pride.
If you're just, excuse me, dry throat, must be from all the heat. If you're an adjuster or a client, you've got to help out those attorneys. They think they're smart enough, but you know better. So let them know what's going on. Don't think that they're going to know everything. They don't, even though they think they do, and we'll see that a little later. Let them know what's going on. Prepare the hearing. Tell them what you want them to know. The more information you give them, the better. Let them figure out what's important for a hearing. There could be something that you don't think is important that ends up becoming the linchpin for success in a case. You just never know. It's better that they get too much than not enough. Tell them what you think that you want them to know. Maybe what your idea of is of what is important isn't what their idea of what is important is. Tell them so that they know what's on your mind. They might think they're smart, but they're not mind readers. Help them out. And Lord knows some of them need a lot of help, or else it wouldn't be so crowded down here. Back to you, Tom.
This one's still yours.
Oh, okay. Ask questions. You know what? If you're going to pay them, pick their brains. Ask them, hey, what do you think about this? There is no such thing as a stupid question. Trust me. We know down here. Ask them, make them provide you with the service you're paying for. They might tell you, hey, that's a great suggestion. I never thought about that. Why? Because there are two sides to every coin. They're only looking at one side. You're looking at the other, but it's still one, which really is hot down here. But it still is only one coin. Make sure that you both know all the sides of the coin, or in this case, all the things that are relevant in the case, so that you can both get the result that you want.
Satan, why don't you start us off on envy?
Oh, okay. Lawyers. Oh, this is a good one. Envy. You want what the other guy wants. You don't like that judge, so let's move that case to another place because, hey, I'll get a better judge. I'll get a better decision. Maybe I'll even get a different claimant's attorney who doesn't usually appear at that part. No, that's not going to work. That doesn't work out, and it hasn't worked out for some lawyers. Hey, Tom, go to the next slide. Let's give him an example of what we mean where it just doesn't work out, where envy bit somebody. Oh, look, it's Mr. Harris. He's back. He's the claimant's attorney that just keeps on giving. He's got a gold star down here. We can't wait to see him. Well, what did he do? He violated a bunch of rules. And when the appellate division caught up with him, one of the things they said was, hey, wait, you're putting in a bunch of venue changes at the board. You want your cases out of Jamaica, out of Hauppauge, out of Manhattan? You want them in Hempstead? Why are you doing that? Well, because he knew that there was a judge at the Hempstead board who didn't bother to have claimants appear before him when they were settling cases on what used to be their procedure for quick resolution of things like schedule losses of use. So Mr. Harris put in about 65 venue changes that they found. Trust me, there were more. Saying that my client wants to go to Hempstead for a hearing, when he knew that the judge wasn't going to make the claimant appear, wouldn't even pick up the phone, just said, oh, we got a paper here? This is okay? I'm going to approve this. Well, he had to put down a reason why the people wanted the venue change. And it's amazing how many people have friends in Hempstead and were going to be staying with a friend in Hempstead. So all these cases came on when in reality, none of them had to be moved from where they were. But because they were moved, Mr. Harris got very favorable decisions from the board. And ultimately, he paid the price for it. Next slide, please, Tommy.
You got it.
Okay. Now, go ahead.
Yep. Envy as it applies to adjusters or clients. I call this the hot potato syndrome or the overgrown garden. It's when no one wants the file. I used to see this a lot when I was practicing for the injured worker. It's when you're given a file that has all sorts of problems. Maybe it's a difficult claimant, perhaps pro se, who has been around forever. More likely, there's a complicated legal issue that just gets more and more convoluted. But you become envious of your colleagues who aren't dealing with this mess. It just keeps getting passed around. And you see this a lot when you're working on the other side, that every time you call up to for any issue, a change of address, anything, it's always someone new on the file and you know that no one wants to touch this. The result is the file becomes neglected, hoping that that it can be passed on and hoping that it gets handled by someone else. But the problem is the changes in the file only get worse. Obviously, we don't want this. Eventually, someone's got to take care of the garden. You got to trim the weeds and make everything right. So this is where envy can really harm the case if you're the adjuster trying to pass along the difficult file. Another example, envy of a different rule or regulation than what's currently in place, or a different time before a new rule has been put in place. An example is currently we're waiting for a signature from the governor on WCL 17 that defines temporary total disability as the injured employee's inability to perform his or her pre-injury employment duties or any modified employment offered by the employer that is consistent with the employee's disability. Now, this totally transforms our understanding of temporary disability if this is signed. Now, this could eliminate labor market attachment, as disability is not based on all employment, but on claimant's specific job. And this would encourage employers to find work within his restrictions. Now, being envious of, assuming this actually does get enacted, being envious of the time of this old rule, the current rule, is really helpful. If the new rule is enacted, you have to deal with things as they are, or would be. For example, we have to encourage retraining or light duty programs by the employer that may not already exist. Envy it of a better rule or of a former rule simply isn't helpful. And ultimately, that's just going to get the case into a lot of problems. We have to be adaptive as things change, even when they don't change for the better. We go to sloth, or sloth, if you're David Attenborough doing a nature documentary. Now, I said pride is considered the deadliest sin, but if you're a workers' comp attorney, I think sloth would be the deadliest of sins, because there is really no positive side of the sin of sloth. Really none whatsoever. For lawyers, a good example would be not providing full effort in writing reports or a brief. And it's very easy to get complacent when you're writing the same issue you have for dozens or perhaps hundreds of times before. It's important to the case to treat every case with the attention that it deserves. Once again, assembly line lawyering, that's not the low-mad way. And it goes back, once again, back to low-mad values. It's personal to us. Oftentimes, an employer's voice is marginalized or ignored by the board. Low-mad exists to provide a voice to employers.
Oh, this is a good one. Not supervising staff or associates. Tom, let's go to the next slide and take another look at Mr. Harris and what happened to him.
As you said, the case that just keeps showing up.
It sure does. One of the charges that the appellate division had in their grievance was that Mr. Harris didn't supervise his firm, that non-lawyers in the firm were putting claimants' names and signatures on venue changes, that issue that we just talked about. Well, when they did this, they forged the signatures, they took them off other documents, and in one case, they submitted a request for a venue change for a claimant who was already dead by the time they submitted the request. Kind of amazing that they did that. We did not help him out in that. We had nothing to do with that. There's a limit as to how far we'll help somebody out, even from help. Anyways, Mr. Harris submits these requests and the appellate division said, well, you're saying that your non-lawyer staff that you probably didn't pay enough to in the first place, that they submitted all this false stuff? Well, you're the one who's ultimately responsible. Your name's on the letterhead. You're the lawyer. You're supposed to know what they're doing. We don't care if they submitted it. You were supposed to be the one watching out and telling them what to do. So because of that, we have a problem with what you did and the fact that you violated those pesky Code of Professional Responsibility rules. And we're not going to put up with that because the appellate division just doesn't like sloth or sloth, if we're being correct about it. And when you do that, they can sometimes get you. Again, if you're a lawyer, know what your people are doing, because in the end, whatever they do reflects on you.
Yes, that's before we go to the next slide. As my old former boss used to say, it comes back to who has the ESQ. So what the assistant support staff or the new attorney may do, even if it's not nefarious, their mistake becomes your mistake. So even if you're overwhelmed and you're counting on them to do the right thing, you can't. That's a big mistake that could get you into a lot of trouble. You have to be responsible for the people that you are responsible for, essentially, when it comes down to it.
Want me to take this one, Tommy?
Why don't you go ahead?
Okay. It's those pesky rules again. You lawyers have rules for everything. And even though in law, everybody knows there's an exception to every rule, the one place that doesn't apply is the rules of professional conduct. There's pretty much no exceptions there. Don't go looking for the loopholes because you're just not going to find them. And if you think you found them, well, guess again. Maybe not. One of the big rules is Rule 1.3, diligence. Do stuff promptly. Be diligent. Make sure you're doing it and doing it well. Don't neglect something. Don't put off that hot potato. The more you put it off, the hotter it's going to get. Figure out a way to deal with it. Don't intentionally fail to do something that you said you were going to do. If a lawyer can't do something, maybe you can withdraw from a case. Better that you withdraw if you don't know what you're doing or can't do something than not do it. Put your client's interests first. Just do it.
While we're on the subject of 1.3, here's a case that highlights the example. With everyone's favorite legal topic, CMS Medicare leaves. Now, of course, we all know these are convoluted, and seems like every couple of years, Medicare changes the rules just to make them more complicated and convoluted. But that's no excuse to protecting the client's interest. Here, in this Hackett case, it was a counsel for the claimant. In a lot of these, we see that they're claimant's attorneys who commit the deadly sin. This was after settlement. Claimant goes to their counsel, and they received a letter that there was a lien that was still owed. And counsel, instead of doing the investigation, tells their client that this is a scam, just ignore it. Well, it wasn't a scam, and this money was owed. And this attorney was in violation of Rule 1.3, as well as 1.4 and 8.4. And counsel was suspended for 2 years. Now, obviously, both attorneys for the claimant as well as for the carrier need to investigate before it is settled on any CMS liens. But again, this without it may be complicated. It may be a pain in the you-know-what. I'm certainly not going to curse, but you cannot engage in sloth when it comes to CMS liens. It's only going to ruin the case. Why don't you take this one?
Okay, sloth. Not that adjusters or clients ever do this, because I am sure that all adjusters and clients, self-insured employers, timely file those RFAs when they get an IME report that says something less than what the claimant is receiving. Because if you don't do that, Well, the claimant's going to continue to get benefits at a rate that you don't think is proper. And then if you have to litigate the case, well, how do you explain an IME report that's a year old when you've got a claimant's attorney or a claimant's doctor who's telling you what the claimant's disability is from 2 months ago? Who's the judge going to believe? The guy you saw him a year ago or the guy you saw him 2 months ago? You can figure that out. You don't need me to tell you that. So if you get those IME reports, file it. Do something. If you have to pay the award, file it. Pay the award. If you're not going to pay the award, appeal it. Do stuff in a timely fashion, even though it can be difficult if you're really busy. Make sure that you do what has to be done when it has to be done. Next slide, Tommy. Here's another thing. Reimbursement requests. That's a biggie. If you have you're a self-insured employer or an employer who just pays the claimant benefits and you want those benefits back, you have to file the request before the award is made. If you file it after the award is made, no good. No good. You're not going to get that reimbursement. That means that the claimant's got money twice. Once from when you paid him, and then again from the award. But if you file that reimbursement request timely, the employer can get back that money. So when you get that request, even if it's 3 weeks into the case and there's never been a hearing, file the request with the board. Once it's in the board file, you can go to bed easy. You don't have to worry about that. You won't wake up at 3 o'clock in the morning wondering, did I file that request for reimbursement? Oh my gosh, what's going on here? Can we appeal this? Oh my gosh, am I in trouble? So do things when you get them, because the longer it sits, the worse it becomes. That guy looks pretty comfortable, doesn't he?
Sure does.
The next problem that adjusters and self-insureds can sometimes have is you get an IME report. You've asked him for a lot of things. And somehow, even though he's a doctor, he's managed to not read all your requests. And he gives you 1 through 5, but he doesn't give you the 6th thing that you want, which is the most important. So now you've got to get an addendum from him. Don't wait to get that addendum. Look at the report. Make sure the doctor's giving you everything you need so that you can have your attorneys defend the claim. Because if you wait, it becomes harder. Follow up and stay on those people. Don't let them get away with it. They might think that they're God because their mothers told them they're God because they're a doctor. They're not. Make sure they do what you ask them to do. You're the one in the driver's seat here.
Now, we've spent this whole time talking about the 7 deadly sins. But let's talk about the counterpart, the 7 saintly virtues. They didn't make a movie about these, but I think it's important to end on a positive note, despite what my counterpart may think. So let's talk a little bit about the positives while we end today's catechism.
Nobody knows those saintly virtues, by the way, Tom, but good luck. Let's hear them.
Oh, well, thank you for the good luck, Lucy. Faith. Have faith in yourself and the team of professionals around you. The workers' compensation system is far from perfect, but there is no perfect system. With a solid group of professionals, we can get the best possible outcome. Hope. Sometimes the WCLJ issues decisions that are wrong. You know it and I know it. And it's frustrating. But that's why we have appeals to the board, or if necessary, to the 3rd department. You hope that the correct decision will be made with the right team of professionals leading the way.
Charity. Oh, this is a good one. But it's not your job to be charitable. You're an adversary. You don't have to be a saint all the time. That's where I come in. But having said that, let's be honest, unless you want to end up down here because you've done something wrong, remember, it is called the Workers' Compensation Board. Workers. So because it's for them, give them everything they're entitled to by the law. Nothing more. You don't have to give them anything more. I mean, it's not charity, people. You don't have to be that charitable. But as long as they're honest, give them what they deserve. And maybe if they're getting too much, well, you know, that's just because some Albany lawmaker decided to listen to St. Tommy and not to that little devil that's sitting on his shoulder.
Fortitude. When a case is challenging, and we all know sometimes it gets very challenging, we move forward with diligence, determination, and collaborative efforts of all. That includes attorneys, adjusters, and all the staff that are involved in the case. Justice, that is the goal. A fair and reasonable outcome as the law and facts are applied. That's what LOMAD is all about, justice.
Yeah, look at their logo. They really mean it.
Temperance. Always have a clear mind when making decisions. An emotional decision is rarely the smart one. And finally, prudence. Generally proceeding in a way that limits risk and any surprises, but occasionally needing to take bold action on a new or novel issue so that good precedent is set on future cases. Essentially balancing between avoiding risk and taking bold action when that in itself is the prudent thing to do. Any questions? All right, seeing none, go forth and spread the good news.
Bye. I don't want to see any of you down here. Bye. Unless you're an HVAC mechanic.
Thank you, Sir Thomas and Lucifer. That was very entertaining.